right now there are about 4.56 million women in the UK workforce who are navigating a biological reality that corporate policy has just, historically pretended doesn't exist.
Yeah, it's a massive blind spot. We're talking about menopausal women, and they actually make up the fastest growing demographic in the entire UK workforce today.
Which is huge. And today, for you listening, we're going to show how that historical blind spot isn't just like uncomfortable for employees anymore. It is actively landing employers in court.
Oh, absolutely. It's resulting in these uncapped discrimination payouts and honestly triggering a massive corporate brain drain.
Right, because experienced people are just leaving. So, welcome to the Deep Dive. I'm your host, and joined as always by our resident expert. And our mission today is to take a really hefty stack of sources. We've got guidance from ACS, the CIPD, the Trades Union Congress.
Yeah, and some major legal analysis, too. We're looking at reports from leading employment law firms like Davidson Morris and Did Law.
Exactly. And we're using all of that to map out the exact workplace rights and legal protections for menopausal employees in the UK right now. So what the law actually says, how tribunals are dissecting these cases, and the structural changes that you need to understand, whether you're, an employee or a manager.
Because frankly, we are way beyond the realm of optional, fluffy HR well-being initiatives. This is a hardcore legal compliance issue now.
It really is. Okay, let's unpack this because the sources show just how widespread the friction is. I mean, 1 in 6 women have considered leaving work due to a lack of support.
And 10% actually have left. 10%.
Which is wild. When you have 10% of your most experienced demographic just walking out the door, you'd assume the UK legal system would have, like, a highly specific law to deal with it, right?
You would think so.
Yeah.
But looking through the legislation, there is actually no standalone Menopause Act on the books anywhere.
Wait, really? Nothing at all?
Nothing specific.
Yeah.
The law is just remarkably fragmented here. You can't, file a tribunal claim for menopause discrimination as its own distinct category.
So what do people do? If you're an employee, how do you fight back?
Well, the legislation hasn't caught up, so employees and their employment lawyers are having to construct cases using this patchwork of existing frameworks.
Ah, I see.
Yeah, the foundation basically relies on 3 main pillars. You've got the Equality Act 2010, the Health and Safety at Work Act 1974, and the Employment Rights Act 1996.
So basically, because there's no specific menopause wrench in the legal toolbox, employees are having to use a legal multi-tool.
A legal multi-tool, exactly. They're borrowing bits of disability, sex, and age discrimination laws just to protect themselves.
And I'd imagine that requires a lot of maneuvering because medically, menopause is a universal life stage for women, right? It's not a disease.
Right, it's completely natural.
So how do tribunals logically justify bridging that gap, like classifying a natural life progression as a legal disability? Because calling menopause a disability might feel, I don't know, really strange to a lot of people going through it.
Oh, it's a huge point of tension. People naturally resist that label. But the thing is, employment tribunals, they don't care about the medical nomenclature. They only care about the statutory test.
Which is what? Exactly.
So under Section 6 of the Equality Act 2010, a disability is defined mechanically. It's a physical or mental impairment that has a substantial and long-term adverse effect on your ability to do normal, everyday things.
Okay, substantial and long-term. What does long-term mean in lawyer speak?
Long-term legally means it has lasted or is expected to last for 12 months or more. And substantial just means, more than minor or trivial.
Well, if we look at the symptoms listed in our sources, things like severe brain fog, crippling anxiety, joint stiffness, heavy bleeding, those easily clear the hurdle of being more than minor.
Precisely. If someone is dealing with that daily for over a year, the biological origin of it just doesn't matter. The legal threshold for disability is met.
Wow. And is there a specific case that proved this?
Yeah, the massive precedent for this was cemented in 2022. The case was Rooney v. Leicester City Council.
Oh, I read about that one in the prep.
Right, so Mrs. Rooney suffered from severe menopausal symptoms. And initially, the employment tribunal actually dismissed her claim. They showed that societal bias you mentioned, they viewed menopause as just a standard life event.
Not a disability in their eyes.
Exactly, but she appealed. And the Employment Appeal Tribunal overturned it. They established a clear legal precedent that if your symptoms meet that specific, substantial, and long-term criteria, they absolutely amount to a disability under the law.
Okay, so let's look at how that disability classification actually shields you in practice, because the sources highlight another case, Davies v. Scottish Courts, and this one hinges entirely on brain fog.
Yes, the water jug case. It's a fascinating one.
Right. So Mrs. Davies suffered from perimenopausal memory loss, just, severe confusion. And she was fired for gross misconduct after this mix-up where her colleagues thought she'd accidentally put her prescription medication into a communal water jug in the office.
Yeah, it was a messy situation.
But the tribunal ruled in her favor. So how do lawyers build that argument? Because the tribunal isn't saying she didn't make a mistake with the water jug, right?
No, she definitely made the mistake.
Hmm.
But they used a specific mechanism under Section 15 of the Equality Act. It's called discrimination arising from disability.
Arising from, okay, how is that different from direct discrimination?
Well, the Scottish courts didn't fire her because she was disabled. They fired her because of the water jug mix-up.
Right.
But her lawyers successfully argued that the memory lapse, the mistake itself, arose directly from her disability, the menopausal brain fog.
Ah, I get it. So the employer effectively punished the symptom.
Exactly. And when an employer penalizes you for something arising from your disability, they have to prove that firing you was a, quote, proportionate means of achieving a legitimate aim.
And firing someone over a genuine symptom-driven moment of confusion was deemed completely disproportionate.
100%. It was totally unjustified in the eyes of the law.
But wait, the disability threshold is notoriously strict, right? You said it has to be 12 months.
Usually, yes. 12 months or expected to last 12 months.
What happens if an employee's symptoms don't meet that? Say it's only been like 6 months of moderate symptoms, but a manager decides to penalize them anyway. Are they just out of luck because they can't use the disability part of the multi-tool?
Not at all.
Mm.
If the disability argument doesn't quite fit, lawyers will pivot. They look at sex or age discrimination instead.
Okay, how does that work?
It requires a completely different legal mechanism called the comparator test. To prove direct discrimination, you have to show that the employer treated the menopausal woman less favorably than they would treat a hypothetical comparator, usually a man in the exact same circumstances.
Here's where it gets really interesting, because I was looking at the Merchant VBT PLC case from 2012, and the legal mechanics there illustrate this perfectly.
Oh, the manager in that case. Just unbelievable.
Right. So Mrs. Merchant's performance was dipping due to her menopause symptoms. She was facing dismissal, so she provided her manager with a formal letter from her GP explicitly stating that her symptoms were affecting her concentration.
Which is a critical piece of medical evidence.
Yeah.
Normal HR protocol dictates the manager should have referred her to occupational health to get an objective assessment.
But he didn't. The manager completely ignored the GP's letter. He decided to assess her medical situation based entirely on his own wife's experience with menopause.
Yeah, you really can't make this stuff up.
Because his wife apparently didn't experience severe cognitive issues, he just concluded Ms. Merchant was using it as an excuse, and he fired her. I mean, how does a tribunal systematically dismantle that kind of management logic?
Well, they apply that comparator test we just talked about. The judge essentially looked at the manager's actions and asked a simple question.
Which was?
If a male employee presented a GP's letter stating that the biological condition, say, severe testosterone deficiency or prostate issue was affecting his concentration, would this manager have ignored the doctor and relied on an anecdote about his buddy Dave to fire him?
I mean, the answer is obviously no. He would never do that.
Exactly. The tribunal ruled it direct sex discrimination. The manager adopted this bizarre, totally irrational approach, specifically because the condition was female-centric. He felt uniquely qualified to just dismiss the medical evidence of a woman.
Wow. And you mentioned age discrimination earlier, too. That intersection is pretty impossible to ignore, right?
Yeah, because menopause typically affects women between their mid-40s and mid-50s. So it exposes them to this dual vulnerability, sexism and ageism, at the exact same time.
The sources cite a 2021 case, McCabe v. Salazar, that really highlighted this. A CEO actually made derogatory age-related comments directly tied to the claimant's menopausal status.
Which resulted in a highly successful age discrimination claim. You just cannot cleanly separate the biological reality of menopause from the chronological reality of age.
And this frequently manifests in workplace culture through what people try to pass off as banter.
Oh, banter is a massive compliance trap.
Let's dig into that, because the line between a joke and harassment is tricky. Like, in the AV Bondmarsh Ltd case, a manager subjected an employee to this lengthy campaign of just disparaging comments about her hot flushes.
Yeah, constantly ridiculing her in front of staff.
So if a manager in that situation turns around and claims, hey, I was just making a joke to lighten the mood, I didn't intend to be malicious, how does a tribunal actually handle that defense?
By entirely disregarding the manager's intention. It legally does not matter what they intended.
Wait, really? Intention means nothing.
Nothing. The statutory definition of harassment under the Equality Act separates purpose from effect. Harassment is unwanted conduct that has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, or offensive environment.
But if we look at the mechanics of that, doesn't it create a huge gray area? If the law focuses purely on the effect of the joke on the victim, how does a judge measure that objectively? Like, what if the employee is just having a terrible day and is being hypersensitive?
The law actually anticipates that exact scenario. Tribunals use a two-pronged test.
Sure.
First, the subjective test. Did the employee actually feel humiliated or degraded?
Okay, that's their personal feeling.
Right. Then the objective test. Was it reasonable for the employee to feel that way given the whole context?
I see.
So, ridiculing a medical condition like hot flushes in front of colleagues, that easily fails the objective test. The environment legally becomes toxic, and claiming it was just a joke offers zero protection.
Okay, so we've focused heavily on the reactive legal battles,
Right.
what happens after an employee is fired or harassed. Let's pivot to the proactive side. What does the legal framework demand employers do to prevent these issues from ever reaching a tribunal?
That brings us to our second legal pillar, the Health and Safety at Work Act 1974.
Right.
Under UK law, employers have a strict statutory duty of care. They have to ensure the health, safety, and welfare of all their employees. And crucially, the regulations mandate specific workplace risk assessments.
And the guidance from the TUC and CIPD explicitly says those risk assessments must consider menopausal women.
Yes, meaning an employer has to actively evaluate the physical and operational environment to see if it's, making symptoms worse.
And the remedy for that is making what the law calls reasonable adjustments. But let me push back on this a bit on behalf of the employers listening.
Sure, go ahead.
If you have an employee whose brain fog is so severe they are routinely making critical errors, maybe they're doing financial miscalculations, or there's a serious safety breach, a desk fan or a uniform tweak doesn't fix that. Doesn't an employer still have a legal right to demand a baseline of competence?
Oh, absolutely. That's a vital distinction.
Yeah.
The law does not say employers must accept poor performance indefinitely or that they have to ignore critical safety errors.
Okay, so what is the point of the adjustments then?
Reasonable adjustments are meant to level the playing field, not eliminate the requirements of the job itself.
Right.
If an employer provides all the reasonable adjustments, let's say flexible hours, quiet workspaces, memory aids, and the employee still fundamentally cannot perform their core duties, the employer can ultimately proceed with a capability dismissal.
But they have to prove they tried to fix the environment first.
Exactly. You have to exhaust the adjustments before you jump to dismissal.
And what do those adjustments typically look like? Because I imagine some managers panic, assuming it requires this massively expensive overhaul of their operations.
The irony is that the vast majority of adjustments are incredibly low cost. I mean, we're talking about providing a 15-pound USB desk fan.
Wow, really?
Yeah. Moving a desk away from a radiator or closer to a window. Adjusting a uniform policy so someone can wear natural, breathable fibers instead of, like, heat-trapping polyester.
Right, just basic human comfort stuff. Easy access to cold water, making sure the toilets are well maintained. It's essentially just tweaking the operational friction.
Exactly. But we also have to talk about administrative adjustments, because the sources place a huge emphasis on sickness and absence policies.
Yes. This is where companies get hit with claims of indirect discrimination, right?
Yes. Indirect discrimination happens when an employer applies a seemingly neutral policy to everyone, but that policy disproportionately disadvantages a specific protected group.
Like rigid absence triggers. The Bradford factor is a big one.
The Bradford factor is a classic example.
Right. For those who don't know, that's where taking, say, 3 separate sick days in a month automatically triggers a disciplinary review or a formal warning from HR.
Exactly. And if you blindly apply that algorithm to a woman who needs to take intermittent days off for fluctuating severe menopause symptoms, you are actively penalizing her for a biological reality tied to her sex and age.
So what does the law require instead?
Employers have to decouple it. Sickness absence related to menopause should be recorded entirely separately from general sickness. That ensures those rigid trigger points don't automatically spark disciplinary action.
And the financial consequences of ignoring that advice are just staggering. I mean, we have to look at the Maxine Linsky v. Direct Line case from 2023.
Oh, a massive, massive wake-up call for corporations.
Mrs. Linsky suffered from menopausal brain fog. And instead of making reasonable adjustments or adjusting her performance targets to account for the symptoms, Direct Line just penalized her.
They initiated disciplinary proceedings.
Yeah, and eventually they transferred her to a lower paid role. She resigned, took them to a tribunal, and the payout was $604,645 to them.
Over 64,000 pounds. And that brings the financial liability into really sharp focus for businesses.
Let's talk about how they get to that number. Because we keep mentioning that tribunal payouts for discrimination are totally uncapped in the UK. But how does a judge actually calculate the financial damage? It's not like unpaid overtime where you just tally up the missing hours.
Right. How do you put a price tag on humiliation or
No.
the stress of being forced out of your career?
Eh.
Well, tribunals use a framework called the Vento Bands, named after a landmark case.
Okay, Vento bands. How do they work?
These bands dictate the compensation specifically for injury to feelings, and there are 3 tiers. The lower band, which currently ranges from about 1,200 pounds to 11,700 pounds, is for isolated or one-off instances of discrimination.
So like a single bad comment.
Exactly. Then you have the middle band, which goes up to nearly 35,000 pounds. That's for serious cases that don't quite amount to a lengthy campaign.
And the top tier.
The upper band stretches past 58,000 pounds.
Yeah.
And that is reserved for sustained, severe campaigns of harassment or discrimination.
And that's just for the emotional damage. That doesn't even include the compensation for lost earnings or pension loss or future loss of income if the employee struggles to find a new job.
Exactly. When you combine injury to feelings with actual financial loss, the numbers escalate incredibly fast.
Wow.
And if we connect this to the bigger picture, beyond the tribunal costs, business owners really need to factor in the hidden operational costs.
The brain drain we mentioned at the start.
Right. You are losing deep institutional knowledge, you're disrupting your leadership pipelines, and you're incurring massive recruitment and onboarding costs. And why? Simply because a manager wouldn't buy a 15-pound desk fan or just adjust a sickness algorithm.
It's madness. And if you're a manager sitting there wondering how to handle this, the momentum is only moving in one direction.
Very true.
Because according to the legal analysis from Torque Law and Davidson Morris and our sources, the landscape is about to become significantly more rigid with the upcoming Employment Rights Bill, which is slated for autumn 2026.
Yeah, the proposed changes are going to remove a massive legal barrier for employees. Right now, an employee usually needs to have worked for a company for 2 full years before they legally qualify to claim unfair dismissal.
2 years is a long time to wait for basic protection.
It is. But the new bill proposes making protection from unfair dismissal a day-one right.
Wow. Meaning a menopausal employee who is unfairly managed out during, say, her first 6 months could take her employer to a tribunal immediately.
Immediately. That fundamentally changes how carefully HR departments are going to have to handle onboarding and those early performance reviews. It forces compliance from the very moment the contract is signed.
And for larger companies, I think the sources said those with 250 or more employees, there's an even bigger structural mandate coming, right?
Yes. The legislation will legally require them to produce and publish equality action plans.
Now, are these just, generic corporate diversity statements that get buried on a website?
No, not at all. These are mandated strategic documents. Companies will have to detail exactly how they are supporting employees through the menopause and, crucially, how they are actively addressing the gender pay gap.
The Unison Guidance makes a brilliant point connecting those two exact issues.
They do.
When women are forced out of the workforce or demoted during their late 40s and 50s, which are traditionally their peak earning and leadership years, it directly widens the gender pay gap. I mean, the two metrics are just inextricably linked.
They really are. And these equality action plans will force transparency right at the board level. The era of managing menopause with a quiet word and a cup of tea is officially over.
Yeah, the law is demanding documented, proactive, and structural policy now.
Definitely.
Okay, we have covered a massive amount of legal ground today. Let's do a rapid-fire summary for everyone listening. The reality is, you won't find a standalone menopause law in the UK, but you are far from unprotected.
Right. You have the legal multi-tool.
Exactly. The Equality Act protects you from discrimination based on sex, age, and disability. And yes, if your symptoms are substantial and last over a year, they absolutely qualify legally as a disability.
And don't forget the Health and Safety at Work Act. It demands that employers proactively assess workplace risks and implement those reasonable adjustments.
From, physical environment tweaks to decoupling menopause from rigid sickness triggers. Tribunal cases are tripling, the Vento ban payouts are completely uncapped, and the legal expectation of just suffering in silence is officially dead.
And for the employers listening, adapting to this framework isn't just about avoiding a 60,000-pound tribunal payout. It is a fundamental strategy for retaining your most experienced, valuable talent in a really competitive market.
Which actually brings me to a final thought I want to leave you with. We spent this entire deep dive dissecting legal frameworks, compliance risks, and tribunal mechanics designed to, protect women from being penalized. We've discussed it almost entirely through the lens of liability mitigation.
All right, avoiding lawsuits.
But what if we flip the script entirely?
In what sense?
Well, what if workplaces stopped viewing menopause as a deficit to accommodate and looked at the actual solutions the law is demanding? Think about the adjustments we've analyzed today. Flexible hours, better environmental controls like ventilation, empathetic management, and policies that don't mechanically punish human biological realities.
That sounds like a pretty great place to work, honestly.
Exactly. If a company masters that kind of flexibility for menopausal women, they haven't just solved a legal compliance issue. They've accidentally created a universally better, more adaptable, and deeply resilient workplace for absolutely everyone.
It's a brilliant reframe. When you design a system to accommodate the margins, you inevitably improve the functionality of the center for everybody else.
Exactly. So keep that legal multi-tool sharp and make sure you understand your rights and your liabilities. But remember that the ultimate goal isn't just surviving a tribunal, it's building a workplace that actually works for the human beings inside it. Thank you so much for joining us on this deep dive. Keep questioning, keep unpacking, and we'll see you next time.